third appeal in Bayer, PLC and NHS Darlington CCG and others.
Some housekeeping first,
Yes.
my Lord. On your desk there's the Advocate General's opinion from the Aventis case that my Lord Justice Floyd asked for. And can I say how infinitely wise...
I think it was me who asked for it, but it doesn't matter.
How infinitely wise you were in asking for it. Shall we insert it in tab 17 in front of the authority B in front of the court's judgment?
It's a judgment of Advocate General Jacobs. It's often generally worth reading.
That is very true. And in this case, he's no exception, because his answer to the first question makes precisely the point I was
Just remind me where we should be putting it. Oh, yes,
Tab 17 is the court, so...
Yeah, so let's put it in front, we'll put it in front of that. Yep.
Because his answer to the first question you see at paragraph 30, report page 7770. And having set out at 30 to 32 the question and the rival positions, and said that he concurs with the view that the marketing authorisation would not be complied with by splicing the two packs together. Multiple packs are not provided for and hence not authorised. 33, I concur with that view.
Yeah.
He then explains at 34 and following why he reaches that conclusion by reference to the provisions dealing with packaging and leaflets in the marketing authorisation. And he makes the point at 39, and this is really directly echoing one of the themes I developed yesterday, that all of that leads to the provisions lead to there being a retail unit. So all of those things are designed to ensure that the unit, when it arrives for retail, is got up in a particular way. And that, of course, ties in with my point, which is one of the ways to rationalise the prior prescription requirement, the way to rationalise it in apposite, is that it's meeting those same clinical concerns in relation to the use of the retail unit. And he also points out very clearly later on in the Advocate General's opinion that, of course, the consequence of the repacking, this is paragraph 60 at page 7776, is that it's repacked into something for which there is a marketing authorisation, and that therefore that was unequivocally necessary within the court's case law at 61. So I hope that's helpful.
Thank you.
Yesterday I had asked you to have a look next at the GPC guidance, and I don't know if you had a chance to look at that overnight.
Yes.
It's in supplementary bundle A.
I think all three of us did.
Very
No, all
quick.
three of us did.
Well, that should enable me to rattle through it that much quicker. So tab 18.
Yes, you said GPC, that's the only thing that confused me, but it's actually the Royal Pharmaceutical Society.
Yes, which is now the GPC. It's been... Oh no, I'm sorry. I thought it was.
I was about to ask you what GPC would in that case stand for, but
It's the... Anyway, it's the regulatory... I think what is clear is it's the regulatory standards that must be complied with by pharmacists when undertaking compounding operations, at least within the NHS. We know that because these are the applicable standards that are enforced through EL 9752. And
sorry, that you say that as if that will be.
I'm going to show you why that's the case, my lord. So, first of all, the author, you can see, is Professor Beanie, produced on behalf of the RPS and the National Pharmaceutical Quality Assurance Committee, which is a kind of coordinate committee with NHS SPS. And then in the introduction, you see aseptic preparation of medicines is an important part of the service provision by pharmacy departments to facilitate accurate and timely administration of complex and demanding activity requiring skilled staff, facilities and close monitoring and control. And then this towards the bottom, aseptic preparation in the UK is only exempt from the licensing requirements of the medicine of the Medicines Act 1968 and subsequent amendments, provided all of the following conditions are met. The preparation is done by or under the supervision of a pharmacist who takes full responsibility. The preparation uses closed systems. Licensed sterile medicinal products are used, and the products will be allocated a shelf life of no more than 1 week. The shelf life should be supported by stability data. The term preparation is therefore used to denote activity without a manufacturing licence from the MHRA, whilst manufacture is used to denote licensed activity. And that goes to the point I'm going to develop about the scale as between those different operations. The first edition of this document gave advice to ensure consistent quality of products prepared in unlicensed hospital preparation units. It provided the defined National Health Service guidelines required by the then MCA. And then over the page, updated and expanded versions of these guidelines have been published since. This new edition has been similarly updated and significantly expanded to provide the NHS with up-to-date standards for aseptic preparation.
Well, if A, we've read this already,
Yeah.
and B, if you do really want us to reread it, just tell us how much you want to read. Standing here reading it out isn't a useful use of time.
Forgive me, so the whole point of this is to maintain quality, and the standards are to be applicable to all aseptic preparations in unlicensed NHS units. You get that from column 189, and from page 190 you get the fact that it is these standards that are then enforced by the EL 9752 procedure.
What is the EL 9752 procedure?
That is the procedure by which NHS SPS audits all of the unlicensed aseptic units of National Health Service hospital pharmacies.
I see, and this is what we see at the top of the
Absolutely.
the top of the left-hand column.
So what you're told here is these are the standards that will be applied to, if you like, mode 3 preparation, pursuant to a section 10.
This doesn't refer as such to the NHS SPS, but that is in fact what is being referred to. Is that
Absolutely.
Right?
Absolutely. And I'll show you some of the documents that show that's one of the very hospitals in question's understanding of the system. So it says, although it is primarily used as the basis of the above audit programme across the UK, the text is also used as standards in several other countries worldwide, and it's additionally used for undergraduate and postgraduate pharmacy teaching in academia. Then chapter 4, the points you get from chapter 4 are these. The process of prescription verification is an exacting one that requires the pharmacist in question to undertake both clinical and, if you like, form checks of the prescription. The clinical check is a check to ensure that the medicine prescribed for the particular patient is indeed suitable for the particular patient. And one of the things that you do through the clinical checks is ensure, for instance, that there is no excipient in the medicine for which the prescription has been prescribed, which the patient in question is allergic to. So you match up the prescription as written with what you know from the patient's clinical records about their requirements. And what's immediately apparent when you go through this rubric is the unstated premise of all of this is that it applies to on-site or internal prescribing. In other words, it's directed at the pharmacy operations to supply the relevant hospital trust's own patients. You get that from paragraph 4.1 and everything that's said about prescribing, not least because there needs to be a current approved list of non-medical prescribers available. You have to know who within the entity is able to write a prescription, which if, for instance, you're dealing with remote provision in mode 3 from a hospital trust in Liverpool, will be impossible to secure in relation to a patient being treated in, for the sake of argument, Gateshead. That not only arises from all of the obligations about access to records of who the current prescribers are, all of the organisational policies required at 4.1.3, it also emerges very clearly from 4.2. You have to verify the prescription from a clinical perspective. Clinical pharmacy verification is the process of verifying against the prescription that the product is clinically appropriate for the particular patient. And aseptic services verification is the process of verifying that the clinical pharmacy verification of the prescription has been carried out, that the prescription constituents are compatible, and that the formulation is stable and the product is the correct presentation for the intended route of administration.
Can you just help me? Which is the passage in your skeleton argument that develops these points?
It isn't developed in our skeleton argument, my lord. But it comes back to the same essential point. You have to go through a gateway. You have to go through a national law gateway. And that national law gateway takes you to consideration of what you can lawfully do under Section 10. Then the further points that emerge from this document are really these. That there are regulatory recognitions here of the dangers of compounding and the dangers in relation to particular issues, in relation to stability, containers, etc. And I should also point out, my lord, in further answer to your question, it's relevant to rebutting the case that's made by my learned friend Mr. Locke about the nature of the prior prescription requirement, because we've said there's a requirement to have a prior prescription, and he, in his supplemental argument, has effectively said, no, you can build up a stock of these things, it can all be done in anticipation of orders, etc. There's no problem, there's no logistical problem in us doing any of these things. And the reason I show you this is to show how onerous a prior prescription exercise is in the NHS that complies with these guidelines. And of course, Mr. Locke's basic problem is he doesn't have any evidence at all, to show that the question of prior prescription has been given any thought and the logistical implications it has. Throughout this litigation, and indeed the subject of ground 2, is the debate between us as whether or not a prior prescription is needed. We say it is, Mr. Peretz says it is, the CCGs say it's not, and then they say, well, even if it is, we'd invent one anyway. And I'm showing you this document to show you that that's not something that you can just simply assert. The process of setting up a compliant prescription system for this type of compounding exercise is massively complicated, and it's not something you can simply assume.
What you're saying is that if they had simply added in to the policy a statement, of course you can only do this if you've got a prior prescription, then that would actually have undermined the whole import of the policy, because it would have negated the ability to actually implement.
Well, at the very least, it brings considerations as to how far you can take the process, i.e. can you do it beyond your own hospital, and what are the costs and implications of doing it. Because there will be massive issues if you are required to have access to the patient records. There are going to be massive data protection issues if it's a commercial supplier and you're providing a commercial supplier with access to clinical records of the patient to check that the prescription is clinically appropriate. There are going to be data protection issues even within the NHS. This is not some trivial exercise.
This is, in fact, a completely independent ground of challenge, isn't it? I mean, if there were no such thing as, if you'd never referred to the terms of the directive at all, you would be saying, by reason of EL 97, that there has to be a prior prescription requirement, and the policy cannot realistically accommodate such a requirement, and you would not you wouldn't have to base it on the opposite at all.
It's a responsive argument, my lord, because
No, again, please, I'm not, belabouring you about whether the point should have been taken before. I'm just trying to get it into my head, because some of what we had yesterday, and I think continuing, but slightly differently this morning, are points which are not reviewed by the judge at all.
This document was referred to the judge.
Was it?
With respect, yes, it
Was
was.
it referred to by
Which
a
is-
judge?
Which
In a
is why
judgment?
it's in the supplementary bundle, and I took the judge through it. It
Yes,
didn't
I
make its
see.
way into the judgment. The
did,
reason,
right.
the reason it's here is we pointed to this very document
Yes, I
as
see.
saying what was required to Section 10. And we had extensive debate about prior prescriptions, and as you'll recall, the judgment says there is no need for prior prescriptions, so you don't get into any of this.
Yeah, I had understood it all, though, to be totally apposite based, the whole prior prescription
sir.
debate.
Well, it
But,
is.
but if you are right, the debate would exist even if apposite had never been decided.
The prior prescription debate arises in three ways. It arises via apposite, as the condition in paragraph 42. It arises through Article 42 bis, because of what apposite and AIFA say about complying with that for manufacturing. They both judgments say prior prescription is required. And it arises through the Section 10 gateway, which is the way to which those are given effect. So you can't get away from prior prescriptions. And the reason I'm showing you this is because if we are right that the prior prescription is required, you cannot accept evidence from my learned friend on the hoof, or an assertion on the hoof, that, well, we can just do all of this, just assume that we'll do a prior prescription, because none of this has been thought through, and it is a fundamental change in the structure of what's being proposed, because what was being proposed was simply sourcing this material in bulk from wholesalers. So if we're right about prior prescriptions, that's game over for the policy, and in fact you don't even have to
It's
get
right about prior prescriptions for what? If they buy them in bulk, then what arrives in the hospital pharmacy is a pack of these little plastic little plastic syringes with a small amount of Avastin in, right? Then it is dispensed by the hospital pharmacy against a prescription, and at that point they can then check whether it's all right. But the point you're making is that it's the making of it, the compounding of it, that has to be.
the compounding.
Yes,
That's
and
why
you say that's.
the compounding in.
But this, I mean, the need to check that the patient isn't allergic to any of the excipients and that it's suitable, that can be done and will be done by the hospital pharmacist when he or she gets the prescription and takes off the shelf the little syringe and says, all right, well, I see what excipients this has in it. Is this all right for this patient? Why can't that be done at that stage?
With respect, my lady, there's several problems with that analysis. The first is that the compounding under our system has to be done by or under the supervision of a pharmacist. That's the first problem. The German system seemingly had no such requirement. So they have a wider domestic gateway than ours, and that's a very material difference between this case, this scenario, this domestic law scenario, and apposite. So any compounding in the UK has to be done by or under the supervision of a pharmacist. That's the first point. The second point is that I'm going to show you when we get to the case law, that if prior prescription means what it means for Article 3, and there's every reason to believe it does, it's an exacting test that requires you to have the prior prescription effectively in your hand before you start the compounding process. You have to have the prior prescription before the compounding occurs. And so ABSA, you'll see, imposes real limits in relation to that. And then the last point is, as I showed you yesterday, even where under the existing scheme there is an exemption from the manufacturing requirements, you still have those requirements in that tedious Schedule 26A, do you remember that I referred you to, the back of the HMR, that says once you've done it, you immediately have to put on a label saying who the patient is, etc., etc., etc. All of that has to be done at the moment the product is compounded. So the reason I'm taking you to this document is twofold. One is to show how in practice, how burdensome a prior prescription requirement is, particularly the minute you start leaving the confines of Mode 2 and start embracing a Mode 3 or Mode 4 solution. That's the first point. But the second point is to show what the document actually shows about risks, and that's in Chapter 6. Now, the starting premise here.
Well, again, you'll remember we've read chapter 6.
Yeah, well,
few minutes ago,
I'll
in
extract
my
the highlights.
Yeah.
The starting premise here is that this is an extremely risky operation that is a long way short of the rigour of a manufacturing process, that however well conducted there is a risk of microbial infection, and therefore, for that reason, products should not be kept for longer than 7 days. And that is absolutely clear. The second thing that's absolutely clear is that the document recognises the particular risks that arise in relation to what it calls complex biopharmaceuticals. That is, biological medicines, like the 3 medicines at issue here. You see that in the second column of 199. And in particular, it says product shelf life should be assigned to ensure the quality of a product, making my point this is all about quality, is suitable for the patient at the time of administration. The assignment of a shelf life can be a complex process, even for small molecules, and then this, and is extremely complex for parenteral nutrition, which needn't concern us, and for biopharmaceuticals, which is us. And then there are particular echoes of that at 6.4.1, where it says, in relation to factors affecting stability, under the risk of chemical degradation, for biopharmaceuticals, the situation is highly complex. It can include chemical changes, conformational changes, that means agglomeration, I think, aggregation, fragmentation, and interactions with containers and excipients. So it shows there's a danger that biopharmaceuticals are going to react with their containers. And then that theme is picked up at 203 at 6.4.10. The nature of the container can contribute.
Well, you don't need to read all this out.
Well, you see,
We've read it this morning, and you can say the point is made at 6.4.10.
yes, and monoclonal antibodies is us.
Yeah.
So there's a risk of interacting with lubricants, etc. And expiry period dealt with at 6.7 shall not be more than 7 days in any circumstances. And then the last.
I'm just wondering how difficult all this actually is, given that I read somewhere that Lucentis is sold in pre-filled syringes. So.
Yes, and that took us about 2 years to obtain a variation, because we had to go through a process of demonstrating that the containers were suitable, that the sealing was suitable, that there was no interaction with the lubricants, that the product was stable when contained in a syringe as opposed to contained within a vial. It was a massive data, and it was an expensive process. And indeed, my learned friends, Miss Stratford's clients, are currently going through exactly the same process, which I think they're about 2 years into. So it's more than 2 years. So it's rather an illustration of the reason why it takes so long is these are very real issues of quality in relation to any such change in container. This is not theory.
It can be done.
It can be done, yes, but then you have to pay to generate the studies to show that it has been done safely. And that is what is being circumvented. So aseptic processing, the parts my Lord has probably already identified as being relevant is 10.1.4.3, page 210. If vials are used for more than one patient, then it should be carried out on a campaign basis only. The campaign basis is defined in 3.1.10 at page 214. The sharing of vials can only be done on a campaign basis, which means 2 or more doses, etc., done effectively in aseptic conditions. And then 13.1.11, this is the basis for the single vial use only being a single vial use. Vial sharing for single-use vials outside the pharmacy aseptic units is unacceptable.
Which page were you reading from?
214, my Lord.
Yep.
So that both confirms the difficulties of prior prescription and the risks in question. Then can I just take you very quickly through some MHRA guidance. Supplementary Bundle B, tab 24. Now the position of the MHRA is it doesn't regulate activities that legitimately fall within Section 10 of the Medicines Act. has no regulatory competence in relation to that. However, there are, as ever, borderline issues, and what it's astute to do is to police that the Section 10 boundaries are being properly observed, and that pharmacists are also respecting the borderlines between the retail supply, which they're authorised to conduct, and the need to hold a wholesale dealer's licence. And this guidance, which was again referred to the judge below, is on the latter topic. It's guidance consequent upon the repeal of Section 10.7 of the Medicines Act. And Section 10.7 of the Medicines Act provided a dispensation to pharmacists to the requirement to hold a wholesale dealer's licence if the amount of wholesale dealing was modest in amount. And I can provide you with the old section. We have copies if you want it. I'll pass them up. So the old Section 7 said, without prejudice to the preceding subsections, the restrictions imposed by Section 8.3 or 8.3a of this Act, and those old 8.3 and 8.3a are in the next few pages, and they contained the then requirement for a wholesale dealer's licence before it was moved over into the human medicines regulations. Those restrictions on wholesale dealing do not apply to anything which is done in a registered pharmacy by or under the supervision of a pharmacist and amounts to wholesale dealing, where such dealing constitutes no more than an inconsiderable part of the business carried on by the pharmacy at that pharmacy. So there was an exemption for wholesale dealing if it wasn't the main business. And after the case of Corona, which I'm going to show you in due course, that was abolished. And the following guidance was then issued to police the borderline between retail activity and wholesale activity. Maybe, my lady, it's best to stick it behind the guidance.
That's what I've done.
So you see the problem described at the bottom of 462. Concerned to ensure the repeal of Section 10.7 does not adversely impact the arrangements for supply of medicines in the UK. In determining how to address this, the MHRA has taken careful account of the particular arrangements for delivery of healthcare in the UK, which involves a wide range of individuals. It sets out the contrasts, and it says, second bullet, in contrast, some pharmacies engage in commercial trade in medicines not solely as part of their professional practice within the UK healthcare system. Other pharmacies may occasionally need to obtain small quantities of a particular medicine, etc. And over the page at MHRA enforcement, it takes the view that the supply of medicines by community and hospital pharmacies to other healthcare professionals in the UK who need to hold small quantities of medicines for treatment of or for onward supply to their patients represents an important and appropriate part of the business. There's further emphasis on small quantities. In such circumstances, the transaction, if they're in small quantities, meets all of the following criteria that the MHRA will then not deem it to be wholesale dealing. It has to take place on an occasional basis. The quantity of supplied medicines is small. The supply is made on a not-for-profit basis, and the onward sale is not for onward wholesale distribution. Now, on any view, those criteria preclude anything that looks like bulk supply. So that's the second bit of guidance I wanted to show you. And then the last bit of guidance is in Sup A, tab 17. This is an MHRA Q&A document, the terms of which we know from our Freedom of Information request will be reviewed in the light of this judgment.
Sorry, I'm slightly behind you. Which tab are we on?
Sup A, tab 17, page 180. I see Mr. Peretz nods when I say they will be reviewed in light of this judgment. That's what NHS SPS has been told by the MHRA. And what I get from this document is a couple of things. The special equipment and special procedures you need in order to compound biologicals. And you get that from 3.3.2, 180A. And what this says, under the heading, can a special...
Wait. Yeah, sorry, this has been put in my bundle, but not in the right place. So 180A to I should follow 180, obviously. Yes, thank you. 3.3.2, did you say?
Yes. Can a specials manufacturer use shared facilities and equipment for biological products? The definition of biological products is supplied by the glossary at 183. And it includes our products unless they are being used for reconstitution compounding. Do you remember I described that yesterday as diluting them? So handling them to make CB.
So where does it say unless they're being...
183 for the purposes of this...
Sorry, no, you're going much too fast.
I'm sorry, my lord.
You quoted... I thought we were on 3.3.2.
Yes, but I'm just saying that the definition of biological products is supplied by the glossary at page 183.
Right.
And then the second paragraph of that says, for the purposes of this Q&A, biological products excludes the reconstitution compounding of commercial biological products such as monoclonal antibodies.
Okay, thank you, I've got that. Yep.
So when you're making CB, it's included. First bullet under there, under 3.3.2, whether you can do this will depend on the nature of the products being processed and the process is conducted. A definition of biologicals manufacturer is included as part of the glossary. It's unlikely that traditional aseptic specials may be manufactured using the same facilities and equipment as biologicals, and a risk assessment should be formed as a basis for any justification. And then the second bullet makes the point that those restrictions will not apply to reconstitution compounding. There are in addition a number of biologically derived products such as monoclonal antibodies. These products should be, which are seen in aseptic MS operations as starting materials for reconstitution. If you're doing reconstitution, those products should be treated as per 3.3.4. So that's what applies when you're diluting Avastin, but it doesn't apply when you're making CB. And that's why, when Miss Stratford took you to Mr. Hambleton's evidence yesterday, paragraph 30 of his witness statement, he referred to the multi-million box that you have to fill in and tick to say whether or not you're making biological medicines. And Newcastle, which is a holder of 10, what is preparing and dispensing under a section 10 exemption? This again informs about what is required for a prior prescription. And again, this was referred to the judge below. And in particular, you'll see requirements for done in accordance with medical prescription for a specific patient. And then this, information from MHA regulatory advice and legal departments is that the requirements of section 10.1a would not be met if there was no prescription in existence prior to preparation, because preparing or dispensing under this provision must be in accordance with a prescription provided by a practitioner. Further, it is considered that there must be sight of the prescription form to satisfy the provision. So the pharmacist must have sight of the prescription for two reasons. Firstly, so the person preparing the medicinal product can ensure that it's prepared in accordance with the prescription, something that's not possible without sight of it. And secondly, so that the pharmacy can satisfy the MHRA of this by being in a position to produce a copy of the prescription for inspection. And what that really comes down to is if you have the prescription, you're within the exemption. If you don't, you're committing a criminal offence. And then there are various discussions, and I apologise for the fact that this particular passage seems to have been duplicated. It's probably easier to take it at 180D. And the same question is asked in a variety of scenarios at 3.12.2, 3.12.3, and so forth. And a sort of cut and paste formula answer is given. What licence is required for the over-labelling of individual blister strips? If this activity is done in a hospital pharmacy to
Carry on, yeah.
180D to supply patients in A&E departments and clinics within that trust a small amount of medicines to get to their GP, this activity can be covered by Section 10. If large quantities of medicines are to be assembled, then the operation should be carried out under a manufacturer's licence and GMP. And then, as for A but supplied outside the trust, these cannot be supplied under the Section 10 route unless hospital pharmacy in question is dispensing the medicine against the prescription they have been given. Some NHS trust hospitals hold a manufacturer's specials licence for the assembly of large quantities of medicines for use within their own legal entity. Now that's relevant. It's relevant to ground 2 because it's a recognition that you need to licence for the purpose of supply to the retail patient, even if everything's happening only within your own legal entity. And they have over time extended to supply to other NHS trusts. And of course, specials can be supplied wholesale.
Hang on 1 second. Quite clear what's being said in B. It's saying that this has happened. Is it saying that that is lawful?
It's effectively making the same point of scale, which is that Section 10 is effectively designed for meeting the needs of your patients on a reactive basis. But if you're doing it on a large scale, it's manufacturing and it requires a manufacturing licence.
Yes, but yes, I see. So basically it's saying that's fine because it holds a manufacturer's specials licence.
If you hold a specials licence, but then it has to be...
Yeah, no, I understand. But if you do, that is fine.
That's fine.
So what does it mean by saying this is because of the way the NHS has evolved? What point's it making there?
I'm not entirely sure. I think it's saying that the reason that one hospital trust is making the special, which is then supplied to another, is due to the fact that, let's say, eye expertise is concentrated in Moorfields, and yet a patient may be being treated in Milton Keynes. I think that's what it's directed at. And of course, a specials can be supplied wholesale under Regulation 1677 that I showed you yesterday. So that's that guidance document.
Well, little C is important as well.
Yes, it is. If it's done by commercial companies for NHS hospitals, they don't normally do this. It would require a manufacturer's licence, and the marketing authorisation of the product concerned will have to be varied accordingly to show the company as an authorised assembler. That's absolutely right, my lady. That's the point I was making, which is that you have to list every manufacturer on the relevant marketing authorisation. I'm sorry, I should have pointed that out. So that's the guidance to the end of the domestic legislation. Can I now deal with my second topic, which will go a good deal quicker, which is the topic of quality risks from the manufacturing process. Now, what should be clear is that to make CB in bulk requires a full-blown manufacturing process.
So sorry, I just want to get the structure of your submissions clear in my mind. I was just looking at the headings I had.
Topic 1 was law and domestic guidance. Topic 2 is the relevant facts about quality risks.
Okay, give me 1 moment. So we're still under law and domestic guidance, are we?
We're still, sorry, my lord?
What are you coming to now?
The facts.
So right, so that we've had the whole of the law and domestic guidance.
Yes, yeah.
Okay, thank you.
So these are the facts, these are the quality
So it's
risks.
very clear to you what your structure is, but it's not always clear to us, so don't
I'm so
resent
sorry.
my asking for help. Yeah. Okay, well, on to the facts.
So, to make CB in bulk, you need a full-blown manufacturing process in which you break the vial packages, you extract and divide the biological medicine using special needles and filters to avoid glass particles, and then you repack in suitable, well-selected, non-contaminated, non-reactive syringes with appropriate lubricants before sealing it and putting it in an appropriate light-proof bag. Now, all of that brings with it the full gamut of manufacturing risks. If you get one of those processes wrong, you affect the quality, perhaps fundamentally, of the product in question. And the MHAR review rightly talks, when it does the survey of the manufacturing sites, therefore, of the manufacturing processes that they're looking to see that the 4 people surveyed actually apply. They plainly think that this sort of bulk operation is a manufacturing process, and therefore we say it must go to manufacturing risks. Now, the judgment below, at paragraph 183, Cord 9, page 182 to 183, set out what we said were the risks, types of risks that arose. And that is indeed the position. But as I hope you will have now seen from the GPC document, those risks aren't just risks viewed by us, or the RPS document. They are risks viewed by the relevant guidance or standards given by the relevant bodies to audit NHS hospitals. And in particular, there is specific guidance about the particular risks and the particular complexities of compounding biological medicines. And we further summarise those risks in paragraphs 15 to 16 of our supplementary skeleton, page 128Q, and especially at paragraph 29 at 128V. And we'll come back to those, but we say really, you've got all the material you need to have a fair, balanced, accurate understanding of the manufacturing risks from the MHRA's supplementary paper, which is in Supplementary Bundle B at tab 22. And I propose to take you through that. This document obviates the need to have any consideration to the contested expert evidence. It's the regulator's view, which is exactly what the judge below asked for. And the relevant passage begins at 353 and following. And I don't know if any of the court have read this before.
Well, let's just find it first. Page 353
Yes,
in the second supplementary bundle.
yes. Tab 22.
And which particular page?
Starts at the top of 353, Survey of Manufacturers Compounding Units. Sets out that a survey was sent out, and you can see an example of the survey questions at page 373. Well, actually, a better one is at 375 because there's less redaction. The letter is headed, Dear Manufacturer.
Which, sorry, 375, did you
Yeah,
say?
this is, so the survey was conducted by sending out these questions to those few bodies that were known to be engaged in the manufacture or compounding of CB. I think there's 4 of them. We don't know their identities, we don't need to for present purposes. Dear Manufacturer, you may be aware of the litigation, etc. and we are seeking to understand in further detail the processes and controls used by different UK manufacturers. In order to gain a fuller understanding, please you provide us with any details of any bevacizumab repackaging operations performed by you, including the following: confirmation as to the facilities in which the repackaged products are manufactured, types of containers you used. We know that containers are a risk. The volume of bevacizumab dispensed, the detailed stepwise procedure to transfer, the methods for sealing, details of secondary packaging, the shelf life and storage instructions, the transport conditions of the repackaged product, if applicable. A summary of any quality control tests that are routinely have been performed on the repacked product, including stability studies, e.g. volume, protein concentration, appearance, microbiological tests, in other words, is it contaminated, particulates, biological activity, etc. And it's those survey responses that are then summarised and their implications in the balance of 353 to 358. So what you then get, going back to 353, is an explanation of the manufacturing processes in the second paragraph. And this, I hope, answers some of the questions my Lord Justice Floyd was asking yesterday about how the process works. Then this, the next paragraph, quality control tests are not generally performed on the ready-to-use syringes, aside from visual inspections for attributes such as volume, labelling, etc. One of the compounding units reports having performed stability studies on the ready-to-use syringes using in-house control tests for attributes, including appearance, subphysical particles, etc. A second site reported stability studies on the existing formulation were conducted in support of clinical trials, but details haven't been provided. 2 sites reported that they have not performed stability testing of their ready-to-use syringes. That's notwithstanding the fact that under the compounding guidance, that's a mandatory inclusion. The process described in the responses would be classified as manufacture if performed in a site which had an MS licence, which is defined in the Human Medicines Regulation as manufacture.
So MS stands for?
Specials. Manufacturing specials. In relation to a medicinal product, involves any process carried out in the course of making the product, but does not include dissolving or dispersing the product, diluting it, etc. And then over the page, after a diagram illustrating the process, at 354, there is then the MHRA's take on the quality considerations. And it contrasts how Avastin is intended to be used as diluted for the treatment of the cancers for which it's indicated. In contrast, when used intravitreally, it's used undiluted and nothing is added, small volumes. These syringes may be stored up to 90 days. Now, the reason why 90 days is permissible is because the sites reviewed had been manufacturing CB under a specials licence. And that's because you can manufacture CB under a specials licence if it is supplied to treat an eye condition other than wet AMD for which there is no licensed treatment. And there are such eye conditions, a number of them. You can also manufacture it under a specials licence or a granted licence by the MHRA if you're manufacturing the medicine for the purposes of clinical trials, like the CAT and IVAN trials that were reviewed by NICE.
So when it says at the top of at the end of the first paragraph on 353, facilities are either subject to MHRA inspection as they hold an MS licence, that
Yes.
we've already explained,
Yes.
or under a Section 10 exemption. So with
Yes.
that the Section 10 exemption would include the clinical trials, would it?
No, the Section 10 exemption is when, for instance, a hospital is compounding it for the use of its own patients. Small scale.
But is that what these manufacturers were doing?
We just don't know, because despite having asked the identities of the manufacturers, despite having tried to join them as interested parties, they've chosen to remain out of the fray.
Right, so it's assumed when they're sent this questionnaire that the details that they're giving are not of unlawful activity,
Yes.
but this is what they're doing, and it seems to be assumed by the MHRA for the purpose of this exercise that they are doing this lawfully.
That's
and
right.
the possible ways in which that could be true is if they're doing it as specials
That's right.
and under the Section 10 exemption.
And with respect, my lady, this goes to part of the debate we had below about the mature market. You can lawfully make CB if it falls within the Article 5 specials exemption, and it's for the treatment of something other than wet AMD. You could even make it for the treatment of wet AMD if that particular patient, for some reason particular to them, cannot use or is not thought to be therapeutically suited to Eylea or Lucentis.
Right, because the questions that they asked didn't include how much of this are you making and for what purpose are you making it.
Quite right. So you have, I think, in a nutshell, why we say the fact that there's a past history of manufacturing under specials licenses tells you nothing about the legality of what's going on and tells you nothing about the existence of a mature market which has been servicing demand quite lawfully historically, because we just don't know what was being done with this product and for what.
And you've asserted, I'm sure rightly, but just if I can know the source, that there are other conditions other than wet AMD
Yes.
for which Avastin may be prescribed for intravitreal
Yes.
use. Where do you get that from?
I believe it's in this document, but it's
Okay.
also elsewhere in the evidence. We can supply you with any number of evidence.
If someone could just give us a sensible reference.
And then again, Mr. Peretz is helpfully nodding that he understands that to be the position. So, we're looking at 354. In contrast, when used intravitreally, it's used undiluted, etc. From a microbiological point of view, the product should be used immediately. In-use storage times and conditions are the responsibility of the user, would normally not be longer than 24 hours, etc. So this is about the dilution of Avastin for reconstitution. Makes my point that reconstitutive compounding is a form of administration and use, and it brings with it the notion of immediacy rather than prolonged storage. Then it goes on to say at 355, Avastin was not formulated for intravitreal use and is not authorised as such. It points out that none of the excipients are novel, so there's no particular issue in relation to that. Then the next paragraph, the specifications which have to be met for the release of Avastin concentrate for solution for infusion may not necessarily be appropriate for intravitreal injection. Monoclonal antibody preparations are
Sorry,
required.
I'm being slow.
What this paragraph is saying, in a nutshell, my lord, is that the specification as to quality for using a monoclonal antibody for infusion
That's
is not
for the cancer treatment.
is not as exacting as the specification for the manufacture of a monoclonal antibody for intravitreal injection. And then it also goes on to point out that quite apart from that, specifications for batch release, which are appropriate for a concentrate for solution for infusion,
Which paragraph are you
it's
looking
the
at?
same paragraph, but about halfway down it,
Right, yeah.
are not necessarily appropriate for a solution for intravitreal injection. For example, levels of specific impurities or aggregates accepted in the MA for Avastin would have been clinically qualified in patients or in other relevant toxicity studies relating to intravenous infusion of the diluted drugs. Such levels would not necessarily be approved based on the data derived from studies for intravitreal injection. And the intravitreal injection standards are set out in a monograph in the next paragraph, which sets minimum quality standards for sterility, particulates, container closure, labelling, uniformity of content and endotoxins. And then there's a reference to the fact that it requires single-dose containers. And then, in particular, in relation to the question of particles, last paragraph, it's also noteworthy that the particles have been implicated as the cause of ADRs, that's adverse drug reactions, such as localized inflammation following the intravitreal injection, and more generally with regards to immunotoxicity. Genicity, sorry. Both Lucentis and Eylea vial presentations are provided with instructions to withdraw the solution from the vial into a syringe using a filter needle. Use of Avastin without a filter needle could potentially lead to the administration of particulates, e.g. particles derived from the puncture of the stopper with a needle, which potentially could give rise to unnecessary adverse events. But then the use or not of a filter needle to withdraw the drug from the vial in order to prevent injections into the eye was not considered in Avastin, so this was not addressed for these sections of use. And then, what in my submission are the two critical paragraphs in this document which bear incredibly close analysis. Another aspect that is not considered in the Avastin MA with regard to...
Do
you want to read it?
I'd rather read it. The last two paragraphs, then you can do the analysis.
Of course. What this is saying, in layman's language, is that for a product like this, the process of aliquoting into new syringes with new lubricants is a process which, for a complex biological medicine, risks changing the essential composition and function of the medicine in question. It says, in terms, that it is not expected that specifications for a biological drug substance filled into a syringe are the same as for the drug substance filled into a vial, due to the changes that can occur during processing and storage. And that's a summary of all of the potential adverse effects identified in the rest of this paragraph, such as the potential presence and effects of leachates and extractables from the syringe, or other product contact materials used for the transfer into syringe, not addressed in the Avastin MA. It's from the change in stability of the
We've read
product,
the paragraphs.
etc. Now, that in our case is modification by any other name, or the risk thereof.
It's really the last sentence, isn't it?
It is.
The licensed biological product is defined by its release specification and by its manufacturer.
Absolutely right, my lord. That was the next point I was going to come to in these two paragraphs. Is for a medicine like this, the process of manufacture is so intimately related to its quality that the medicine is defined by the process of its manufacture. And that's why it's taken both of these drug companies that Ms. Stratford and I represent so very long simply to get an approval for the same medicine, not a different monoclonal antibody, the same medicine into a new syringe. It's precisely because of these risks. And you will see when we come to the case law that none of this is addressed by the CJEU. The CJEU simply assumes, on the basis of the facts referred by the national courts, that this is some kind of bare repackaging exercise. And the term they use throughout, and I'll show you in the judgments, is repackaging, which is of course the term from the Aventis case. Now, this manufacturing risk is also allied to a regulatory risk. Because unlike manufacturing, whether under a conventionals licence or a specials licence, which is rigorously enforced, no doubt, by the MHRA, the EL 9752 standards are enforced by NHS SPS. And it's for that purpose that I do want to show you some of the new materials, very, very briefly. And no doubt you will look at them de bene esse. So, unagreed bundle 2, please. Sorry, unagreed bundle 3. Entirely misspoke. So I just had a bundle explosion, forgive me.
So have I. Yeah.
The position is really set out in Mr. Kelly's witness statement, where he explains page 4 of the bundle, paragraph 11 and following, the further inquiries that were made in the light of the CQC's response. And that resulted in a freedom of information request being answered at page 20. And this is confirmation, if confirmation were needed, repeatedly, that NHS pharmacy units...
Sorry, I haven't got to page 20 yet.
This is page 20
in the exhibit. It's, I'm most grateful to Mr. Matt that he's reassembled my bundle for me, above and beyond. So, tab 4 is the freedom of information correspondence to which Mr. Kelly refers. The response starts at 18.
Who is the response from?
It's NHS England and NHS Improvement, which I think is the parent body for NHS SPS. Parent division. And you can see the answers to the substantive questions we answer. There are a number of pharmacy aseptic units in England, approximately 145 which are unlicensed. In order to maintain standards, they're subject to an audit in line with Executive Letter 9752.
Are you at some point going to be taking this to Executive Letter 9752?
Yes.
You can't just see
Yes.
the page.
Well, if you want to go to it,
No, I'm happy if you. I just wanted to know that we would see it at some point.
yeah. Well, page 40. We can jump to it.
Page
now.
40 of the same bundle.
Same clip.
Okay.
The background to the audits are that during 1994, 2 children died in Manchester Children's Hospital as a result of contaminated intravenous feeding fluids prepared by the pharmacy department. The preparations were made under a Section 10 exemption and therefore did not require a manufacturer specials licence. The granting of such licence, that's a specials licence, follows stringent inspection of the applicant's site and regular inspections thereafter. And effectively, therefore, what happened was to fill or attempt to fill the gap by the absence of regulation. An investigation by the MTA found serious deficiencies in many pharmacy hospitals. Risks at 60% of
Well,
NHS,
again,
etc. So there was
I keep saying, for any long passage, why don't you just ask us to read it because it's quicker? How much have you now read all you want from that page, or do you?
yes, ma'am.
Okay.
It explains the problem that was
Yep.
being addressed by the auditing requirement.
Yep.
And I'm helpfully told by Mr. Peretz that the relationship between NHS England and NHS SPS is explained in the letter, which I was going to take you to at 152, so we'll have a look at that in a second. If you go back to the Freedom of Information response, you can see throughout all of the answers.
So I'm just. So page 18 is all the questions.
That's right, and the answers
Right, and
begin at
then-
page 20, my lady.
Right, so what they've done is they've reprinted the question in bold, and then
That's
is
right.
it their answer which is in non-bold type?
Absolutely.
Right, so which question is it that you're...
Well, to summarise what they say the responsibility for audit is NHS SPS pursuant to the Executive Letter 9752, and they say repeatedly that the standards that are applied are Quality Assurance of Aseptic Preparation Services, Standard 5th Edition, which is the RPS document I showed you when we started this morning. That's what it's headed. That lengthy document I took you through, chapters 4, 6, etc. And they repeatedly say that that is what is being applied to the hospital pharmacies.
And that
the last
includes
piece of the
prior,
equation.
that includes the prior prescription.
Yes. Yes. So we know that those standards are applied in Mode 2 and Mode 3. Mode 4 is a gap, it's a hole. We don't know what happens in Mode 4, and that in itself is a concern. Or the commercial supply.
Yes, no, but my point is you wouldn't expect, you have you asked questions about it? I thought your questions were about NHS facilities.
They were, yes.
So this wouldn't deal with Mode 4.
No, but I'm saying we can't get any information about Mode 4.
Precisely.
All that we know is that it's done by a pharmacist. And many of the pharmacists, if it's not a registered pharmacies are like typical high street or dispensing pharmacies where there are premises inspections. If it's not done there,
Right, the information that you've got about the commercial ones is the answer to the questionnaire that the MHRA sent out, and it's assumed that they all have specials licences or are making the product pursuant to some Section 10 exemption.
if they can, we don't see how they could, but
Right, but that's what's been assumed in asking them the questions.
So the reason why we say a product risk is allied to a regulatory risk is that even though these standards are enforced in the NHS, we received a very peculiar unsolicited letter from DAC Beechcroft at page 152 that took pains to point out that although there is this audit,
Wait a minute, hang on. You want us to...
page 152 of the
Look
same
at it, we
book.
need to get to it. Yeah, okay, I have it now.
And who are DHCB?
They're the solicitors representing NHS England. And the passage to which Mr. Peretz kindly directed me is the last paragraph. NHS England commissions the special pharmacy services that are delivered by NHS SPS. They're commissioned pursuant to an MOU between the Secretary of State and NHS England that special pharmacies...
Sorry, I am... the last paragraph starting the role of NHS SPS.
152. What's
The last paragraph on
152.
152. I thought you meant the last paragraph of the letter.
No.
Okay. Yep, carry on.
NHS England commissions the SPS services. There's an MOU. Copy of the MOU is attached. I'll show you that in a second. NHS SPS does not itself have a separate legal personality. It's a team of individuals who are based in a variety of NHS organisations, lacks support functions such as expertise in FOIA requests. However, NHS England does not manage NHS SPS. And then could you read the last paragraph under the whole heading, the role of NHS SPS?
Yes, thank you. Yes, thank you.
So it's a regulator with no teeth, unlike the MHRA, notwithstanding the fact that the MOU at 154 and following describes special pharmacy services at 4.1 as being, understandably in the light of the Farwell report, critical to the provision of safe and effective patient care.
Where are you?
156, my lord.
156.
So the MOU starts at 154. This was attached to the letter. Pharmacy services are critical to the provision of safe and effective patient care.
Where are you reading from?
4.1.
4.1. Thank you.
And if you read Roman 2 and Roman 3, you can see that that embraces hospital pharmacy services. Now I can, lastly I hope answer my Lord Justice Underhill's question about the inspections, because we have inspections reports pursuant to the Freedom of Information requests of the various NHS trust hospitals that would be relevant for Mode 2, and there are 82 and following. The first one is in relation to Newcastle upon Tyne Hospital, 9th of May 2019, so quite recent. It's got a conventional traffic light system for the workings of the traffic lights are explained if you want further detail at page 45. Orange means deficiencies that require initial action.
They're all explained at the top.
Right. Yeah, of course they are. So, and you can see there are major issues in relation to minimising risk with injectable medicines, aseptic processing. That's just conventional aseptic processing, not biologicals. Over the page, Newcastle Teaching Hospital. Again, major issues for minimising risk with injectable medicines, aseptic processing.
How does it help us to see all these individual reports?
Shows you that there is no review of the capabilities of the hospitals in question for undertaking compounding of biologicals. It's just bare aseptic services. So that's the material on risk.
So are they actually making these biologicals?
No, the material in bundle 2, the Freedom of Information request we sent to those hospitals, makes it absolutely plain that they are not presently intending to make any CB themselves.
Right, so the assumption is that these facilities are good enough for doing what it is that they're doing.
Aseptic, standard aseptic operations, not biological compounding.
Right.
I don't know quite where that gets at. Your point, which I've certainly already got, that none of the hospitals in these trusts are presently planning to,
Or capable of.
well, possibly planning to compound in bulk, or we may say at all, and therefore these inspection reports don't report on how they are doing that activity.
Well, the inspection reports show that even within their conventional activities there are problems.
Well, so what? There's sometimes problems, but
Yeah,
the policy can't be relevant to the questions we've got to decide whether there are some problems in the specialist pharmacy services at these hospitals.
It is relevant to this extent, my lord. The exercise required by the Let's test that my learned friend took you through yesterday asks you to investigate in the real world what's going to happen. In the real world, there is no prospect of this policy being implemented anytime soon by these hospitals.
All right, but that okay. Well, I'm not
That's
spending
the
time
sort.
with it.
So what you're saying is that mode 2 is a theoretical,
Entirely theoretical.
and also that one might say, well, of course they're not doing it now because there's uncertainty over the legality of it. But if we were to decide that it was legal so that they could do it, you're saying that actually it would take quite a long time for it to
Absolutely.
to them to bring their facilities with these problems up to sufficient standard.
That's exactly the point. So when you look at the impact of the policy and the massive demand it's going to create, the only way that that demand can be created without there being problems of patient supply will be through mode 3 and mode 4. It's just simply not a demand that's capable of being met by mode 2. So, next topic, my lord, in my rostrum of topics, the CJEU case law.
Yes, thank you.
Because industrial supply is gone, there are only 5 cases that I need to show you, and I hope to rattle through those first 3 really pretty quickly. I'm not going to go through the cases of Dufar and Menarini, which my own friend Mr. Locke places great reliance on. We don't say they're in the least bit relevant to the question that arises here which is whether or not this product can be lawfully supplied or not. Questions about reimbursement for products capable of being lawfully supplied are a downstream issue. So the first case is Commission in Poland, Authorities Bundle B, tab 20. This is an Article 5 case. What are the key takeaways I invite you to get from this case? It's the familiar one, but the familiar one applied in the context of this directive, that exceptions must be extremely strictly construed to preserve the integrity of the directive's regime. And it's also the clear principle that financial considerations, notably costs for national health service systems, however strong, cannot be relied upon to justify, to bend or depart from the rules in the directive. The facts of the case were tolerably simple. Poland had introduced some legislation under which effectively it provided for the use of medicines that were authorised as medicines in the state of export, let's say across the border in Germany, but had no marketing authorisation in Poland. Now, under the scheme of the directive, you can use, as a party applying for marketing authorisation, you can use the fact that the medicine has already been approved in another member state to apply for a marketing authorisation in the second state in question. But you still have to get a marketing authorisation in that state. And there's a procedure involving the reference member state, in this example Germany, and the new member state, by which you get a marketing authorisation. And what the Poles were doing was effectively cutting out that entire process and allowing the import immediately from Germany of medicines on the basis that they would save money by so doing. You see that from paragraph 1 of the judgment. It's, of course, an infraction case brought by the Commission. You see it from paragraph 1, and you also see it from paragraph 5, which sets out the relevant Polish law. The relevant condition is at the end of subparagraph 1 of Article 4, the Polish law, so long as, or on the condition that, the medicinal product imported is allowed to be marketed in the country from which it was imported and holds an up-to-date marketing authorisation. That's an authorisation in the state of export. Commission said there is no justification for rewriting the directive in this way. It's an unlicensed medicine. You see the nub of their arguments at 11 and following. And they said it may apply not just to patients of an entire hospital sector, it might also apply to wholesale marketing at 14. Poland, at 16, sought to justify its position by an ambitious reliance upon Article 5 of the directive. And the reasoning of the court starts at 537. 26 to 27 explain that the requirement for a marketing authorisation and the prohibition on placing on the market without one is intended to fulfil the twin objectives of the directive, which are to attain first the elimination of hindrances to trade, and secondly, the protection of public health, the recitals I showed you and familiar case law. Then they go through the schema of Article 5, and they say at 30, it's apparent from the wording of that provision that implementation of the derogation for which it provides is conditional on the fulfilment of a set of cumulative conditions. Very strict interpretation set out at 31. 32, more specifically, the power must remain exceptional in order to provide the practical effect of the marketing authorisation procedure. So what it's saying is it can't get to such a scale that you're subverting the marketing authorisation procedure itself. 33, the Advocate General's right to say that the specific needs of the patient's point is a crucial one. A contrary interpretation would conflict with the aim of protecting public health, which is achieved through the harmonisation of provisions relating to medicinal products. So it's saying it has to be a patient-specific need, because anything wider than that would undermine the directive. concept of special needs applies only to an individual situation justified by medical considerations and presupposes that the medicinal product is necessary. And at 35, they emphasise that that has to be, therefore, as a result of an actual examination of the patient on the basis of purely therapeutic considerations. So money doesn't enter into it, it's about therapeutic considerations. They say at 36, the directive doesn't permit anything else. At 37, they arrive at the conclusion that where medicinal products having the same active substances, the same dosage and the same form as the doctor considers appropriate, that he must prescribe, there cannot in fact be a question of special needs within Article 5.1 necessitating a derogation. Financial considerations cannot in themselves lead to the recognition of the existence of such special needs. So you can't expand the concepts of the directive merely because it will save money. And unsurprisingly, then, they conclude that the law doesn't satisfy Article 5.1 at 40. And then Poland advances a variety of arguments from 44 onwards. The argument at 46 bears a lot of similarities to some of the arguments Mr. Locke has invoked by reference to member state competence to set prices and set the financial stability of its national social security system. And that argument is addressed and rejected. At 47, it said that although EU law does not detract from the power of member states to organise their social security systems and to adopt in particular provisions intended to govern the consumption of pharmaceutical products in order to promote the financial stability of their healthcare insurance systems. In other words, although they're not prevented from organising things so as to save money, the member states must, however, comply with EU law in exercising that power. In other words, the power has to be exercised by reference to lawfully available products. It must be pointed out next that Article 5.1 is not concerned with the organisation of the healthcare or its financial stability, but is a specific derogating provision which must be interpreted strictly, applicable in exceptional cases where it's appropriate to meet special medical needs. And therefore they reach the conclusion at 50 that finance is irrelevant. So that's the first case. The second case, Corona, it's the next case in the bundle, tab 21. The takeaway here, the point I derived from this case, is that where a pharmacist is engaged in wholesale dealing, the pharmacist will require a wholesale dealer's licence. That's what led to the repeal of Section 10.7 of the Medicines Act. And the logical takeaway of this case also is that where a pharmacist is engaged in manufacture for the purposes of wholesale dealing, that will also require authorisation. And in fact, Corona is the first case to grapple with the meaning of Article 42 bis, which is why you see it cited in Apposite and IEFA. So the facts of the case, well, the case starts at 3 and following, setting out relevant provisions that I took you through yesterday. I think the only point I need to flag in particular, because I didn't flag it yesterday, but it's specifically relevant to the Corona case, is 77 subparagraph 2 of page 542. So Article 77 of the Directive, Act 2, says where persons authorised or entitled to supply medicinal products to the public.
So sorry, I've got lost. Where in the judgment are we?
Paragraph 8 of the judgment, citing 77 of the Directive, and it's subparagraph 2 of Article 77.
Thank you, yeah.
Where persons authorised or entitled to supply medicinal products to the public, so pharmacists are entitled to supply medicines to the public, may also, under national law, engage in wholesale business, such persons shall be subject to the authorisation provided for in the paragraph. So it seems a pretty clear provision that's saying if you're doing retail but you're also doing wholesale, you have to comply with wholesale. But Mr. Corona had better ideas. You can see the facts at 22 and following. He was relying, I think, upon Italian provisions, not unlike the old Section 10.7 of the Medicines Act, to say, I've been authorised to act as a pharmacist, and because I have been authorised to act as a pharmacist, I needn't get a wholesale dealer's licence. And so the Tribunale di Palermo referred some questions set out at 26 about the meaning of Article 77.2. And those questions are answered at the foot of 544 and following. The court says, in essence, what's being asked is whether Article 77.2 of the directive is to be interpreted as meaning that the requirement to obtain an authorisation for wholesale distribution is applicable to a pharmacist who, as a natural person, is also authorised under national law to operate as a wholesaler in medicinal products. So what it's saying is automatically, by dint of his registration as a pharmacist. Mr. Corona, 30, is of the view...
So they're saying that the national authorisation for pharmacists allows them, as a matter of national law, to wholesale medicinal products.
Exactly. In truth, what's being asked is the national provision that confers authority to do wholesale dealing compatible with Article 77.2? But you know you can never ask a question quite so blunt or make a point quite so blunt. So that's what's really being asked. Is the Italian law compatible? And Mr. Corona seeks to argue that it is, because he draws at 30 a distinction between pharmacists and everyone else. Pharmacists are special, according to him. And the CJU says at 31, that argument can't be accepted. What's instructive is the process of reasoning that then follows at 32 through to 36. Because what they do is they look at Article 42 bis and the exemption given to pharmacists from the requirement to have a manufacturing authorisation and say that only applies to pharmacists engaged in retail supply. And it must follow from that where the pharmacist is not engaged in retail supply, the pharmacist needs a manufacturing licence. And since manufacturing and licences and wholesale dealers' licences go together, that's proof that the directive had no intention to exempt pharmacists from the requirements to hold a wholesale dealer's licence. And you see that in particular at 34 and 35. So this is the beginnings of the firm insistence in the case law that Article 42 bis is all about retail supply, in contradistinction to wholesale supply. And you see at the end of 35, it says, it follows that where such manufacturing processes are not carried out for the purposes of retail supply of medical products, medicinal products, pharmacists are not exempt from the requirement to hold an MFA, which also covers the authorisation for wholesale distribution. Because if you have an MFA, you don't need to get an additional wholesale distribution licence. But then 36 is also extremely relevant. It says, to allow pharmacists to engage in activities as wholesale distributors of medicinal products without special authorisations would confer on them an unjustified competitive advantage vis-à-vis other persons authorised or entitled to supply medicinal products to the public who are required to apply for such authorisation. And in our submission, precisely the same logic applies to the requirement for a manufacturing authorisation. So to permit bulk manufacture in this way for wholesale supply is unfair competition with manufacturers who have to comply with GMP and the hundreds of pages of EU and domestic law in relation to manufacture. And the logic also applies directly in relation to marketing authorisations. Over the page, well, the court concludes at 37 that pharmacists are included in the wider category of person, and at 39, it's apparent from the wording that only pharmacists and persons authorised to supply medicinal products to the public who confine themselves to this activity, that is, who do not engage in activity as wholesale distributors of medicinal products, are exempt from the requirement to obtain an authorisation. The only other passage I would refer you to is 43 to 47, which makes the point I made in opening, that insofar as they are retail activities, truly so called, then that is an area only partially regulated by EU law. You see that at 43, and in particular you see the conclusion at 47. Given that the retail of medicinal products has different characteristics from wholesale distribution, it cannot be simply presumed from the fact that pharmacists satisfy the conditions governing retail supply that they also satisfy the conditions laid down by harmonised rules for wholesale distribution. So what they're saying is because retail applies all kinds of other obligations about what premises you operate and why, you can't assume that because your premises have been authorised for retail purposes, they're authorised for wholesale purposes. That's Corona. The last of the quicker cases is the case of ABSA. I'm going to go a little bit out of chronological order here because I think it's sensible to look at Apposite and IEFA together. ABSA is at tab 25 of the same bundle. The facts of this case were as follows. There was for a long time in Sweden a state monopoly over pharmacies. And during the period of the state monopoly in pharmacies, two products, one was called Metadone APL and the other was called Noradrenaline APL, were supplied effectively as specials. There was no marketing authorization at all for either of these drugs, which were powerful drugs containing controlled substances. One's a methadone substitute. And the way that the Swedish pharmacy system had organised itself was that those medicines were effectively to be made up as specials, and the state, which was running the pharmacy services, wasn't getting a marketing authorisation in relation to that. So they were taking the starter ingredients and making the finished medicines at the relevant dose for anyone needing these powerful drugs. Once the pharmacy system was privatised, the pharmacies were spun out, and a company came along and applied for marketing authorisations in relation to the two products. You see this at 23 through to 27. And of course, once they had marketing authorisations for the two products, the pharmacies could no longer make them as specials. So the question that arose in ABSA was as to the extent to which the products could be made under section 3.1, compounding powers. So could they be made in the pharmacy, not in reliance on Article 5, but in reliance on Article 3.1? And there were ancillary...
Who got the marketing authorisations for the products then? The manufacturers?
So you see this, my lady, at 25 and following. It's the company Apotek that got the marketing authorisations. And it was... so ABSA, it's so confusing. 23, it's ABSA, which produces the drugs with marketing authorisations, and Apotek, which was the pharmacy, which was manufacturing them. So you see at 27, the medicinal product Noradrenaline ABSA was authorised on the 3rd of July 2009. Metadone at 28 DNE was authorised since the 10th of August 2007.
Right, but the pharmacies didn't hold those marketing authorisations.
No, what the pharmacies were doing was making the same products that they had used to make as a special, now as an Article 3.1 compounded medicine. And the issues in the case were, what could they do? How far could they go using Article 3.1, in effect, to carry on?
Just being very slow, make sure I've understood it. The only relevance of Article 5 is that removes the basis on which they'd been done before, which was that there was no drug with a marketing authorisation for these indications.
That's right. The other relevance is that the gateways for Article 5 are much wider, because Article 5 doesn't require a prior prescription.
Yeah, okay.
So,
as you say, they're thrown back on Article 3.
So thrown back on Article 3, and the issues in the case, you can see from the questions referred at 30, were effectively, can they do this under Article 3? And can some of the conditions or permissions that were available under Article 5 be effectively read across into Article 3? Because what the state pharmacy wanted to do was to continue business as usual, and for it, business as usual was manufacturing the products in bulk in anticipation of a subsequent request for the supply of the medicine. That's what they had been doing, And the question was whether or not maintaining that same system was compatible with Article 3.1. You'll see that it becomes clearer when you look at the analysis in the court. So the questions referred at 31 in the first case, and 31 and following, 30 in the first case, 31 in the following, have a common first question, which is about the interpretation of Article 3.1. There is also a common question about the extent of advertising being permitted. And it's that first question that then is answered at 598 and following. And we needn't trouble you with anything from effectively 33 through to 51, now that my learned friend has conceded the industrial supply point. Because what the court does is say, embedded in the question, there's a question about industrial supply, and it then sets out its answer to that. Though I do point you to the test at 51, because you may think it has, what they think of being industrial supply may have some bearing on this. They say it's either large scale or serial production of magistral formula in batches is characteristic of industrial preparation or manufacture, and therefore within industrial supply. So from 53 onwards, they're then dealing with the questions about Article 3. At 54, they emphasise again, citing Commission in Poland, that this too is an exemption to be strictly interpreted. They point out that the referring court, in referring to Article 5.1, is irrelevant for the purposes of the application of the exceptions in Article 3.1, which requires only that the conditions expressly provided for in that article be met. So they're saying don't carry over stuff from Article 5.1 to Article 3. And that theme is continued at 56 and 57. And at 58 they say, it's apparent from the wording of Article 3.1 that provision, that the implementation of the exception for which it provides is subject to a set of conditions being met concerning the preparation of the medicinal products in a pharmacy in accordance with a medical prescription, which must be for an individual patient. The conditions are cumulative, so that Article 3.1 doesn't apply if any one of them is not satisfied. They then explain what a medical prescription is as defined, and they say at the end the view must be taken that it must of necessity be prepared on the basis of a prior prescription issued by a professional person qualified to do. And then at 61 they say, in addition, the medical prescription must, in accordance with that provision, be for an individual patient. It follows therefrom that it must be for a named patient, the patient must be identified before the product is produced, and it must be produced specifically for that patient. Then you get to 62, which makes the point that I was trying to make very poorly beforehand. According to the referring court, noradrenaline APL was prepared by Apotek on the basis of needs known in advance, to be used in emergency departments in any event on the basis of orders placed before a specified patient had been identified, i.e. the system was a stocking system. And at 63 to 64, they say that is impermissible. And 64 is particularly evident. It says, as the Advocate General notes, the view must be taken that in order to benefit from the exemption, a medicinal product must of necessity be prepared after the prescription for a specified patient has been issued. It can't apply to the subscription supply system to which a non-hospital pharmacy subscribes on the basis of an estimate of its short-term needs, and that point is reiterated at 65. The prescription must be issued before the preparation in question. Now, the only other point to take away from this is, of course, this Article 3.1 provision is a gateway. It's an exemption. These are the minimum conditions to be met to get through the EU gateway. But once you're through the EU gateway, the operation of the business in question is governed by national law. It's national provisions here, just like in Article 5, just like in Article 42 bis, that then regulate the legality of the exercise in question once the EU conditions have been satisfied. And then only one other point to note, At 66 to 67, they look at Article 3.2, the other provision, and they make the point that I made earlier, that I said I'd come back to, that what that requires is direct supply by the pharmacy to the person asking for the thing to be made up according to the pharmacopoeia. And that is yet further proof positive that that form of direct retail sale is, but for this exemption, within the scope of the directive. That's back to my making the stuff in the back of my shed argument. So those are the easy...
Probably less, we won't hit the jackpot twice, but I think, especially in view of the express reference made by the court, it would be useful to have the Advocate General's opinion in this one as well.
Of course, we're over lunch. We're trying to pare things back.
No, I'm not being critical at all.
No.
But,
So apposite, here the Advocate General's opinion is where you have to start the chain of inquiry. Because on any view, there's a significant difference in approach between Advocate General Sharpston and the court. Apposite is at Advocate General Sharpston's AGO is at tab 22 of this same bundle. It begins with what is, in my submission, an extremely helpful historical summary of the development of the directive in question, which started with Directive 65/65 as amended from time to time. There are 2 points in the historical survey up to paragraph 12 that I want to emphasise in particular. The first is paragraph 8, which makes the point I made yesterday, that there was a specific directive introducing controls over wholesale supply into the old Directive 65/65, and it was that directive that led to the notion of the whole supply chain needing to be controlled. And indeed, recital 35 in the current directive is almost a straight cut and paste job from the recitals from that old Directive 92/25. I've got copies of that directive if you're interested, which I doubt you are. But that's an important part of the history, and that's why we say recital 35, properly understood, is all about wholesale dealing. The second point to note is the history in relation to the genesis of the centralised community authorisation in what was Regulation 2309/93. And the reason for it was that it was thought necessary to have a centralised approach in relation to the technologically advanced medicinal products it covered. In other words, precisely because of the complexity of these products, and precisely in order to avoid potential national divergence of views in relation to all the issues posed by biological medicines, down to whether or not a container interacts unacceptably with the biological medicine, those matters were centralised and subject to a procedure in which the EMA evaluated for the entire community. So it's important to realise the very reason we're even looking at the regulation at all is because of biological medicines, and the reason biological medicines receive that treatment is because of their complexity. Advocate General Sharpston then sets out a pretty comprehensive list of the provisions in the directive. By contrast to the court, she does set out at 25 the key wholesale dealing provisions. She then, at 26 and following, sets out the provisions from the regulation, and at 33 she made the point again, which I made very badly yesterday. The regulation says nothing about manufacturing or distribution authorisations. These are governed exclusively by the directive. Then the German law is set out, and then the facts at 35 in particular, and we need to look at these carefully. These are the facts in the order for reference, and effectively 35 sets out the SMPC of Novartis's medicine. 36 effectively sets out the SMPC of Avastin. 37 then describes Apposite's operation. It produces pre-filled syringes containing only the dose of the medicinal product in question which is necessary for a single injection. These products include Lucentis and Avastin. Now that's an important point to appreciate about this case. The operation of Apposite predated my client's move to pre-filled syringes. And so their products, Novartis' products at that stage, were available in vials which were overfilled, as recital 35 indicated. So one of the things that Apposite was doing was taking my client's products and repackaging them into the pre-filled syringe. That was the first thing they were doing. The second thing that they were doing was repackaging Avastin. So there were two things at issue here, and you can see immediately that that complicates the matters from the perspective of the risks of modification, etc. And then it goes on at 37. For that purpose, Apposite draws off the contents from the original vials into several sterile syringes, which are then supplied throughout Germany for injection by a doctor. And then this, as the facts, the product itself is not modified. Production occurs under sterile conditions and according to Apposite, in each case on the instructions of a pharmacy which has a doctor's prescription for a specific patient. Now stop again. As a matter of German law, it may be that you can unpack a pharmacy operation in that way and the pharmacist simply places an order with another party that does the process of compounding. That may be true as a matter of German law, but under our law, Section 10 of the Medicines Act only permits the compounding to be done by a pharmacist. So this splitting up between Apposite and the pharmacy is not replicable here. It's a very important point to understand about this decision.
Okay, can I just though understand exactly what happens? The product itself is not modified. I mean, you may have more to say about the fine-tuning of that, but that basically means that there's no change to the active ingredient. Production occurs under sterile conditions, okay, and in each case on the instructions of a pharmacy which has a doctor's prescription for a specific patient. I don't quite... Does that mean that a local pharmacy in, let us say, Berlin, has a doctor's prescription saying, I want a vial of
A syringe.
of, let us say, Lucentis for ocular injection. Practice is probably going to be it's probably going to be a hospital or at least a clinic, isn't it? It's not going to be a GP.
It'll be a private clinic. It could be a private hospital.
Yes. So and with that bit of paper in their hand, Apposite go to a vial of Lucentis and draw off.
No.
Well, what does it mean?
It means that the pharmacist has contracted out the operation of compounding to Apposite. That's as we understand it. Apposite is not itself a pharmacy.
No, that's not what.
Yeah, and I have a...
It's the sequencing that's this.
Absolutely. So in the German system, there must be a manufacturing dispensation that goes beyond pharmacists and goes to other forms of repackaging operation.
Well, that may be, but that's not the question I'm asking. The question I'm asking is just what happens. I'm a patient.
Yep.
I go to a clinic.
Yep.
And the doctor sees me and says, "You've got wet AMD. I need to inject Lucentis."
That's right. You present
with a syringe, and I write you a prescription.
That's right.
Hair Underhill, 10 syringes of Lucentis.
Yep.
Take this to the pharmacy, and
That's
they'll
right.
get it for you. So you walk down the street to the nearest pharmacy. The pharmacy has that prescription.
Yep.
And sends it, or maybe doesn't physically send it, but assures Apposite that it has it,
That's right.
and says to Apposite, please produce 10 syringes.
That's right.
They do not produce those 10 syringes until they have that bit of paper in their hand, or at least the assurance that it exists.
That's right.
That's right. So there is no bulk operation. There might be bulk in the limited sense they might have 100 of these each day, so there's a lot of compounding goes on. But it's not bulk in the sense that it's done in advance. It is done literally for each prescription.
Yes.
I'm sorry if I'm spelling this
That's
out, but I want to
absolutely
understand.
right, my lord. And the only thing I would add to that is that the ability to contract out the compounding by the pharmacy to another body, which is not a pharmacist, Apposite, is a function of the German
Well,
rules.
you've made that point already, and
Yeah.
it may indeed be important for reasons you're coming to, but at the moment I just want to understand what
You've
happens.
understood the basic setup, absolutely
Right, but the person who has to come within the exemption is the pharmacist.
Yes. But what we're going to see, my lady, is where you get to with the Apposite exemption where it applies, you get to a position where the prior prescription requirement becomes entirely detached from Article 3. So Article 3 contains a restriction that it has to be done in a pharmacy, whereas paragraph 42, the key provisions, that's not one of the conditions. So that effectively, what the court has done is created a set of conditions amounting to a de facto further exemption, if you like, but not one that is geared to whether or not the activity is conducted in a pharmacy. That's what's happened.
How's that?
We're getting ahead of ourselves, aren't we?
You are a little bit, because I want to show you the relevant paragraphs.
Yeah.
How does that relate to construing Article 3.1 very strictly?
Well, what is apparent, my lord, is that what the relevance of Article 3.1 is for the source of the prior prescriptions operation. Because what the reasoning of the court is, and I think the MHRA agree with us in relation to this, is we can invent this or discover this new Apposite exemption because what we're permitting is analogous to that which would happen under Article 3.1 in the hospital pharmacy itself. And so the prior prescription, if that is the reasoning, the prior prescription requirement has to be the same, has to be of the same quality as identified in ABSA. Does that make sense? I'll show you the passages.
Was the question then really whether this subcontracting, as you called it, precluded reliance on Article 3.1, or was it assumed that it did preclude reliance on
But
Article
the case was being argued outside Article 3.1
Yes, because Apposite was not...
because it was not a pharmacy.
Yeah.
They had to go outside Article 3.1 because Apposite couldn't get itself within Article 3.1. And this goes back to a perennial issue in this case. We've always said there may be scope for lawful compounding of CB under Article 3.1, but you'll have to comply with the conditions of Article 3.1, which brings with it prior prescription, and it brings with it all the regulatory constraints and assumptions as to the scale of the operation in question.
If you accept this creates a new, as it were, freestanding.
Yes, that's the only way you can read what comes later.
And that must be in play as well, but you say it's still subject to the prior prescription.
Absolutely, and I'll show you the paragraph that says as much. But we say if it is in effect a new exception, it has to be construed strictly, just like the other exceptions. It has to be construed so as to reflect the public safety goals of the directive and the investment incentive goals of the directive, and to stop unfair competition, etc. So that was the facts at 37. The 38 makes the point that there was no authorisation in question, no marketing authorisation, and that the argument became an argument about what the word developed in Annex 1 of the centralised regulations means. In other words, was this process one developing a new biological medicine? And the parties were disputed about that.
Sorry, forgive me, I'm just confused myself for a moment. And I remember when reading this that it was confusing. What is Regulation 3.1?
That's the centralised regulation. So if you go back to authorities
Yes, I see.
bundle A, it's Annex 1. If you want to have look back again.
No, that's fine. Okay.
Yes, that's one of the many confusing things about this
Lots
judgment.
of things
Is that
Yeah. So the requirement to use the centralised regulation procedure is in relation to the development of biological medicines. And so they were saying there is no marketing authorisation. It's a biological medicine, there needs to be a marketing authorisation. And the parties in Germany thought the issue turned on the word developed. And you can see that at 40 and following, leading to the question. And the question is important because it's the source of this vexed word modification. Does the term developed in the introductory sentence to the annex extend to processes in which only portions of a medicine which has been developed and produced on a ready-to-use basis are drawn off into another container after being prescribed and ordered at the time concerned by a doctor, if as a result of the process the composition of the medicinal product is not modified, and therefore in particular to the production of pre-filled syringes which have been filled with the medicinal product which is authorised under the regulation. So that's where the word modification comes in. It comes in from the national reference. The Advocate General then analyses the provision, and her conclusion is this whole notion of development is a red herring. At 42 and 43 she accepts, and 44 she accepts the Commission's argument that it is, and she explains why from 45 through to 48. And effectively she's saying all that the regulation does is transfer the party competent for the assessment of the product in question from a national authority to the Commission. It's the same test in the directive. Nothing of substance has changed. You see that in particular at 48. It's to delineate those products that require authorisation under the centralised procedure, but it can have no substantive effect. So nothing turns on the regulation versus the directive because it's the same set of approval criteria. And she says, whilst that might provide an answer to the question, it's not a very helpful one. So she reformulates, irony of irony, she reformulates the question at 50. And she takes as the premise, which too does not involve any modification to the composition of the product be carried out, etc. Then the Advocate General's analysis at 51 through to 62 is effectively this, that there undoubtedly has been a change to the product which would require a variation. If it would require a variation on the part of the manufacturer, it must make the product without such approval into an unauthorised product. And a third party couldn't conceivably be in any better position than the manufacturer themselves. And you see that in particular at the end of 60.
Hang on one second.
And there are a couple of stages,
Yeah.
there are a couple of stages in her reasoning that are important in reaching that conclusion. The first stage is that she says the concept of placing goods on the market in the context of the directive is not the same as the concept used in exhaustion of rights. Why? Precisely because, and this is where she relies on Article 35, because the purpose of the directive is to ensure a full chain of custody throughout the distribution process of the product until it is supplied to the end member of the public. So she's saying it must be a continued and continuing evaluation as to whether or not the product has changed. It's not enough that it just started off as being an authorised product, and you see that in particular at 57 and 58. An authorisation must therefore be in place on every occasion on which the product is made available on the market until the point in which it's been disposed of by being supplied to the public. Now, of course, that reading is also consistent with the provisions that I showed you, which do not appear in the Advocate General's summary, namely Article 41A, which requires a manufacturing authorization only to be for a product for which there is an MA. And it's also consistent with Article 77, which says that the manufacturer may only distribute products for which there is an MA and the provisions in good distribution practice. That's entirely consistent with that seeming structure of the directive. And she says at 59, any other interpretation would fail to satisfy the requirement that control be exercised over the entire chain of distribution. And therefore she considers that the fact that there is no marketing authorisation is fatal to this operation. Then what she does, at 63 and following, is analyse the potential impact of Article 3. But of course the first thing she does, given the facts of the case at 63, is emphasise that they apply, that exemption applies to medicinal products prepared in a pharmacy. And she says the purpose of Article 3.1 exception right at the bottom is clear. They remove from the complicated, not to say expensive system of marketing authorisations the supply of medicinal products to the public in circumstances arise, if not on a daily basis, at least regularly throughout the member states. They presuppose that the preparation of the product in question will be carried out in a pharmacy, that is, by or under the supervision of the pharmacist. That language actually echoes the exact language of Section 10, which I suspect the Advocate General had litigated for the UK government. The public is therefore protected insofar as preparation will be the responsibility of the qualified medical professional with expertise in the dispensing of the products concerned. Now, what that's relevant to is it makes good the point I've made time and time again. The prescription here is protecting you against risks of misuse or misadministration. It is not protecting you against more. The additional limitations imposed by these provisions ensure that the pharmacist is supplying the products on an individual basis. And then this, if that were not the case, there would be a risk that the preparation would not be carried out with the necessary degree of supervision. Effectively pointing to a risk that the minute you bulk up, the risks posed by the system change. Where a pharmacist...
That's what I might call a soft point. There's no reason why that should be so. If in the morning I'm pretty sure from past experience that I will get two prescriptions during the day for what is a fairly standard type of product, and I decide to go into the back room and prepare them now, and blow me down if it's 11 o'clock and 2 o'clock the prescriptions come in, there they are, I can provide them straight away. There's no reason at all to believe I'd be less careful doing that than if I'd waited until 10 o'clock and 2 o'clock. I just wanted to spell out what the point is. It's a soft-edged point.
I don't actually...
If you're making 100...
don't accept that.
Well, why not?
Let me explain why. Because if you've got the products sitting around at the back of your dispensing pharmacy, and it's a product for which risks of biological contamination are particularly acute, the longer it's sitting around, the worse the position is. And that's why...
Well, that would be a reason why you might have to throw them away at the end of the day.
Well...
But this is... I just want to understand what kind of point she's making. She's making surely a human nature type of point, not a legal point. That's what I meant by a soft edge point. Or have I misunderstood it?
Well, I think she is making a human nature point, which is that but for the stringent regulation of the kind requiring manufacturing to be conducted by an experienced, qualified person, the risks posed by scale and manufacturing are different to the risks posed by simply preparing 1 or 2 doses. If you're a pharmacist and you have got the prescription in your hand and you then concentrate on the exercise in question, you can be expected to concentrate on it. If you've been given an order for 10,000 and it's what you do for the next 3 or 4 days, your attention may well slip.
No, well, that's fine. I mean, it's not a particularly difficult point, but I just wanted to make sure I'd understood what the point was, and I think that is it.
Yeah. And then at 65 to 68, she effectively says, in fairly plain language, that Appetite's not going to be able to get itself into that because you can't ignore the requirement for a pharmacy. and therefore it won't benefit. And then the last topic she comes to of relevance is Article 40.
Sorry, I just want to be clear about this. It's important to be clear about every part of the facts of this case. Apposite is certainly not a pharmacy.
That's right.
Is it stated anywhere, or at any rate implicit, that there isn't, as it were, a pharmacist working in Apposite supervising the process?
I think it's necessarily implicit, because otherwise the argument would be conducted by reference to Article 3.
Yes.
And the whole purpose of inventing the apposite exception was to get round Article 3. That was what was driving it. I can check. Again, I have
No, it's rather what I've assumed.
someone
but
more
I-
familiar
but-
with the German litigation sitting behind me, and that, I'm told, is the position. And that's why at 66 to 68 she says, you can't ignore the pharmacy requirement. And then at 70 and following, she analyses Article 40 of the directive. Now, given the conclusion the Advocate General has reached, which is that you don't get over the the marketing authorisation hurdle, necessarily anything about the manufacturing authorisation is surplus to requirements on her analysis. And she says at 72, the manufacturing authorisation forms a series of controls, and effectively her reasoning at 72 to 73 is, well, just because German law might provide a retail exception for manufacturing that Apposite can benefit from, doesn't detract from the fact that they don't have the marketing authorisation that they require. So you see how Article 40 on her analysis becomes unnecessary, surplus to requirements. Then the last passage, economic considerations. Ireland has pitched in and made arguments that this is necessary to save money, and that argument is effectively rejected at 75 in terms entirely consistent with Commission and Poland, and at 76 she emphasises in terms that the derogation provided in Article 42 must be undertaken solely for retail supply. And that is taken up and run with in the court's reasoning. It seems to me that these would include such activities where they are carried out on behalf of patients in a hospital pharmacy. So on the Advocate General's analysis, mode 2 is retail supply, but everything else isn't. So that's the Advocate General's analysis.
So she says it must be retail supply, but if the pharmacy is producing it for in-house use, then that does count as
Yes,
retail supply.
so the Advocate General would see mode 2 as retail supply. As would we. Judgment of the Court, next tab, tab 23. There is a recital of the facts that is not very different, except for the fact that the Court doesn't look at any of the wholesale dealing provisions in its recitals of the relevant provisions of the directive. The facts as set out at 18 through to the order for reference don't differ, so far as I can see, in any way materially from the facts set out in the Advocate General's opinion. The crunch is what is said at 23, and that seems to conform exactly to what Advocate General Sharpston has said, except that it points out that the final price of an injection is considerably lower than the price that would be paid using the medicines as marketed. Now, what you then get to is this. Nowhere in the facts have any of the issues that we've identified as being relevant to quality and thus composition, continued composition, nowhere are they cited. No one has addressed the specific risks of degradation of biological products. No one has addressed the specific risks of leaching, of interaction with the plastics in the container, of interactions with the lubricants, or the very dangers inherent in moving these complex biological products, which may form agglomerates or particulates, etc., or may change their stability. Shelf life is not addressed, stability is not addressed, none of this features at all in the factors and facts before the CJEU. Nor do they look at the provisions of Annex 1 of the marketing authorisation regime that I took you to that addressed those specific topics and point out the specific risks and the particular risks in relation to biological products. Those also are unaddressed. What the court is doing, quite plainly, is proceeding on the facts as presented by the National Court. That's the first point to note about the review of the facts. The answers to the questions are then at 570. They too reformulate the questions. But note this, and this is highly significant in my submission. At 34, Novartis and the Czech and Greek governments submit that the activities such as those at issues in the main proceedings amount to repackaging and are not covered by the marketing authorisation granted for original medicinal products, with the result that the activities are unlawful. The language is about repackaging. We see throughout the judgments that same language of repackaging is looked at. Apposite, the German government, Ireland, the Portuguese government defend the contrary position, namely submitting that such activities, i.e. repackaging, do not require the grant of a marketing authorisation additional to those already granted.
But it was Novartis that was arguing that it was repackaging
Yes.
rather than
Yes.
manufacturing.
Because it was very easy to demonstrate on the basis of the Eventis case law. It was logically inescapable that there was a change to the marketing authorisation. They didn't need to go into the horrendous technical detail of the biological medicine. Why? Because there was a recent decision of the CJEU saying even if you change the packs and splice two packs together, that needs a new marketing authorisation, which is why it's the Eventis case that featured in the argument before the courts. And it seems like, I suspect, a slam dunk in those circumstances. And what the court then does at 40 and 40 through to 42 is find a way through this. So having said, on the basis of effectively, generally, if you make a change, you need a new marketing authorisation at 38. They say at 41, when it prepares ready-to-use syringes in order to respond to orders placed by pharmacies in which patients have handed in prescriptions for such syringes, a company such as Apposite does not use any biotechnological processes. So it's not using some process to make some particular strand of DNA or something of that kind, listed in point 1 of the annex, nor moreover does it supply anything to those pharmacies in advance, either directly or indirectly, through wholesalers. So wholesalers seem to be problematic. Furthermore, it's apparent from the order for reference, and in particular from the wording of the question raised, first, that the Landgericht Hamburg proceeds on the basis that the composition is not modified. So that's an assumption of fact. And second, that the content of the syringes that have been refilled in that way is administered to the patient by the prescribing doctor, who has thus decided himself to treat his patient using such syringes. In such circumstances, and this is the crunch paragraph, provided that the referring court does in fact find the processes do not result in any modification of the medicinal product, that's condition 1, and condition 2, that they are carried out solely on the basis of individual prescriptions making provision for them, there is no ground for considering that the activity carried out can be equated with a new placing on the market. So there are two conditions: no modification and prior individual prescriptions. And that is a condition is absolutely apparent simply from the wording of the paragraph and from the wording of paragraph 41 that precedes it, because it introduces why it is that the prescribing doctor is relevant, because the prescribing doctor has addressed and identified the clinical needs and is going to personally administer it, so that there is no risk that the medicine is going to be used in a way not only outside the SMPC, but outside the use contemplated by the treating doctor. So that's the crunch paragraph, from which we say the prior prescription requirement, even in the Apposite exemption, arises.
when they say any modification of the medicinal product, they must there be referring us to the active ingredient, because it's as plain as a pikestaff that there'd been a modification to the in the Aventis sense by putting the stuff into the
Yes.
syringe.
So what they're plainly doing is saying a change to the composition of the product, a new active ingredient added to it, that would be a modification. What they're also plainly doing is saying bare repackaging is not problematic. But what we say is left unaddressed, as per my learned friend's 3 bullet points that I showed you yesterday, are all the quality concerns in relation to manufacturing which affect the quality and the continued safety and efficacy of the product.
But that's your problem, isn't it? It's not a... Sorry,
No.
no. I'll let my lady go next.
The difficulty is that they set out what the facts are as to what Avastin is doing. And they don't say that must amount to modification of itself. What they seem to be saying is somebody has to be sure that that does not lead to the accidental or unintentional modification of the product. But your difficulty is that although they seem to be absolutely clear what it is that Avastin is doing, they still seem to contemplate that it's possible for the National Court to find on the facts that there's no modification of the product.
Absolutely.
They seem to be... so either you say, well, that's just wrong, and they were wrong because they didn't address their minds to all the problems that there are, or they're saying, well, those problems have to be addressed by the National Court, looking at how careful Avastin is. But what they seem to be saying is that it's possible to carry out this process without thereby modifying the product if you do it very carefully, even though it affects the shelf life and all that.
Well, they don't address the shelf life, maybe, with respect. They don't address... I mean, the shelf life of Avastin is 2 years, and we know that it's either going to be reduced to 90 days or 7 days, depending on what's happened, by dint of the changes and the risks of changes that happen through
Yes,
the
but
process of
the answer
repackaging.
to that is all part of the process of the National Court satisfying itself that the processes don't result in any modification of the medicinal product.
Quite. And our case is not that Avastin determines the issue in our favour. It's never been that. Our case is that the question of modification is a question of fact for the National Court. That's our case. Our case is not that it says in these circumstances it is a modification. Our case is it says in terms it's for the National Court to decide whether or not there is a modification. They've had the facts as referred by the National Court, but as you'll see, and I'm going to show you the rest of it, they time and again say it's up to the National Court to verify that there is no modification. And there are 2 problems for the court. One is that the debate is polar by reference to safety by design, active substances and repackaging, and the question of quality and quality factors which affect composition is not addressed. So the test is underspecified, and they haven't really explained very clearly what is meant by modification. So the test has that uncertainty. One can't escape from that. But the second issue is it's a test for the National Court to apply to the facts, and the facts are the facts at page 356 of my learned friend Mr. Peretz's client's document, which detail how intimately involved the nature of this product is with its manufacturing process and how manufacturing risks a change to the composition of the product. That's the issue.
So that answer is consistent with my Lord's point, because what the court certainly did know that the packaging was going to be different.
Yes.
And the mode of administration was going to be different.
Yes.
Did they also know that it was going to be used for an indication other than that
Yes.
for which the market... They certainly...
Yes. It must
Because that wasn't true for Lucentis, but it was true for...
Absolutely.
And that's in the facts somewhere,
Yeah,
is it?
yeah. It's absolutely clear they knew that. But
So
you have
all
right.
those things they knew.
Those things are all factors that go to whether the product once made will then be safely used. And because they're under the clinical control of the doctor who's prescribed it, all of those issues, the leafleting issues, the labelling issues, etc., are addressed by the fact that the medicine is under the effective control of the prescribing doctor. I go back to my point, it's perfectly rational to have a binding condition in paragraph 42 linked to prior prescription if what you're concerned about is bare repackaging. That makes total sense. It makes total sense because all of the concerns that packaging address are met by the doctor's control over the administration of the product. It makes no sense as a condition if the concern is in relation to the quality of the product in question, because the doctor is reliant on the pharmacist, totally reliant on the pharmacist being able to produce a quality, safe medicine to be used. And once you get into that, which wasn't investigated in the case, why? Because everyone thought bare repackaging was enough to trigger a demand for a new marketing authorisation on the basis of the recent Aventis case, you realise that the case hasn't addressed the central issue to be addressed. And that's its problem. Now, can I show you the rest of it just before lunch, and then I'll deal with it.
It's not necessarily, it's its problem insofar as it's relied on as giving us the answer in this case.
Yes.
It's a perfectly, if your explanation is right, it's a perfectly legitimate decision in its own right. And not, you don't have to say it's wrong.
No, you don't. But what it leads to is a question of factual inquiry, which has to be applied. Has this product been modified? And once you see the changes and their significance, and changes in stability and shelf life are about as basic as you can get, then you see that it's going to the fundamental characteristics of the product, because it may have lost its efficacy. So injecting, it may produce no beneficial effects, whereas a better made product would have produced the beneficial effects. That's the vice at the heart of this case. Anyway.
Sorry, I just want to be clear about this, that the inquiry which is left to the court is effectively, would be into the procedures operated by Avastin and the factors such as shelf life and the processes that you would say for transporting it from Avastin back to the doctor.
We say one.
But that would essentially be, well, would that be satisfied as such by finding that everything that was done was in accordance with national law? No.
No. Not least because you've lost the safeguard of a pharmacy. So the significance of the appetite exception is it detaches it even from the safeguard of the activity occurring.
But the court can't have thought the inquiry was an inquiry about every batch, that you look at it to see whether some particles are slipped into the batch.
No.
The court must have thought that the inquiry which the domestic court would have to make would be whether the processes were such as to ensure adequate quality control, given the different route of administration and different
adequate quality control to leave the product unchanged. Unchanged. It has to be unchanged, because the minute the product has a different shelf life,
attention please,
has a different stability profile.
Attention please. This is the Incident Control Officer.
Well, let's just wait for this to pass.
An evacuation is in progress in the Queen's Building. Do not enter this area until further notice.
I suggest we just rise.
Your area is not affected.
Because
Please continue, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the Queen's